right. Well, welcome. Thank you guys so much for coming. Common misconceptions about tenant rights. So as you are well aware, we're a property management company. That is what we do. We protect the interests of both the landlords and the tenants. And frequently we see them crossing lines that they shouldn't have in both directions. So we are kind of just here today to help give you a little bit of guidance as far as knowing how to steer your clients in the right direction so that they don't find themselves in either, financial trouble, penalties, or legal trouble. That would be the worst case scenario. So a lot of these instances that we're going to cover today are somewhat, unfortunately, commonplace with how landlords treat residents. We've all heard those horror stories. So again, we're just going to be here in your corner and help you through it all. Share some insight as far as what's going on. All right, so Landlord-Tenant Act, again, I already kind of said it. So the majority of the information we're going to cover today is outlined. This is a very in detail, in-depth document, and it's a very exciting 60-page read. So should you want to, you're welcome to go and delve deeper into the ins and outs of it. I did paste the URL for where you can find it in the chat. So if you missed that, go check it out. But we're gonna hit the highlights here for you today. Some of it is a little bit of shedding light. Some of it you may already know. So today, who we are, I am Michaela Nelson, Marketing Director with Service Star Realty. I've been here for probably about three and a half years now. So I've kind of grown from the front desk to the administrative side of things, all the way through to helping with the business development side of things as well. I am the main contact for HomeSmart. So those of you that are from HomeSmart joining us today, you'll have seen my face all over the program. Sorry about that. Unfortunately, it's just how it goes. Ashley Bean is the Business Development Manager. She's on today as well. She's going to be covering some of those slides. She's been with us about a year now. You're coming on your anniversary. She goes through a lot of the new client questions. So as you have investors either purchasing properties or inheriting properties that they're wanting to have rented out, she's their main contact. She helps them and guides them through the whole process. David and Jora, co-founders, designated broker, presidents, you name it, we couldn't be here without them. So they're going to be sharing their wealth of knowledge with us today as well. So I look forward to hearing more. All right.
Yeah.
Oh, I try. Some of the things we're going to take away today, how to properly access a property. What kind of notices do you need? What kind of timelines do you need to pay attention to? And just to make sure you're not stepping on any toes. How to avoid financial or legal penalties and what's at stake if things go wrong. Expectations at the end of your lease. So just a little bit of insight from an agent standpoint of what to be on the lookout for when you're either purchasing or selling a tenant-occupied property. Security deposits and who's responsible for what, setting realistic expectations. A lot of times people just try and get away with whatever they can. So we're going to share some guidelines on that for you. Know how your client can toe the line when it comes to fair housing. There's a huge, intricate topic. We're all aware of how scary fair housing can be. So we're going to shed some light. I wonder how many times I'm going to say that today. Shed some light on that angle from a property management side. Common infractions that are often considered retaliation by the courts. I think that's pretty fair or pretty self-explanatory, but we'll share some examples with you, as well as some best practices. So first and foremost, Miss Ashley.
So getting proper access. So first, we have a times people think they own the home, that they can just show up at the property, even if they're just going to look at the backyard, but you still need permission to even get into the backyard or on the front yard. So you need to determine what the access is for. Is it maintenance needs? So if it does call in because they have a leaky toilet, that is giving access. So you're able to come in and tell them that the plumber is available tomorrow to fix the toilet, so it doesn't need the necessary 48 hours. Is it a scheduled inspection, or is it for a showing for sale? So those notices do need a 48-hour notice for non-emergency access. And let's say you're texting, emailing, calling, and leaving a voicemail. Those aren't, I guess, tangible notices. So you would have to leave or accept a certified mail. So it could take up to 7 days to actually have proper notice, and that way you have the receipt and it's held up in court. And it's very important to hold to these guidelines because you'll find later the consequences and the remedies if you don't. And we don't want to abuse these guidelines because the tenant does have rights. And so we can't go up and show up and knock on their door and be like, I'm here to show the property. You have to give proper notice.
We've had nightmare owners that, you know, they send us pictures of, well, there's weeds in the backyard. Well, okay, Mr. Owner, how did you come to find these weeds in the backyard? You know, you clearly accessed the property, stuck your camera over their picture or over their fence. That's a big no-no.
Well, we have this one horror story that happened to one of our colleagues. Because some of the tenants are really savvy nowadays. They know the law, plus there's so many services that are available to educate them. It happened to one of our colleagues that a realtor was showing the home, and they were accessing the home, and for every single showing, the tenant was just collecting the business cards. And at the end, they took not the realtor who was showing it, but obviously the landlord, the property owner, is responsible for all the expenses. And we're going to talk about what the penalty was in that case. But it was realtors coming in, showing the home, leaving a card at every showing. And then, like I said, we'll see what the penalty is for that.
Expensive.
Very expensive.
And you can include in your lease, which we that they have to allow access with a 48-hour notice.
Yes.
Mm-hmm.
And that's not just a phone call, leave a voicemail saying, hey, I'm showing tomorrow afternoon at 4, or 2 days from now at 4. No, that's a given written confirmed notice, and you don't have that unless you have an email responded to, or a text, or a certified letter. So anyway, it's very, very sensitive in regards to it, and it can be costly if you don't.
Yes. So the problem with the notice is not that you absolutely cannot get their understanding and you cannot come to an agreement. The problem is that when you don't have it in a text message that they are okay with it, or you don't have it in an email response that they are okay with it, and you didn't send the certified letter, you can get penalized for showing up without proper notice. So the issue is always getting penalized for breaking their quiet enjoyment and showing up at the property. And like Ashley was saying, or Kayla was saying, it is enough to set foot off of the sidewalk into the front yard. If you have unfriendly tenants, of course, this whole thing is to help you guys. So we are talking about situations when you're selling a home and you have to talk to tenants of allowing you to show it, and you have a buyer who wants to see the property, and there's this pressure situation, and it's so easy to just overstep your bounds in your excitement of having a buyer and wanting to show the property. But as long as you know what's at stake, which is, in case, I guess I'm going to let the cat out of the bag, it is 1 month of rent. Every time you set foot on the property and you don't have the notice, if the tenant is savvy, the courts will immediately award them the money for each showing. So anyhow,
All right.
it's a good idea to give notice for sure.
All right. So again, we kind of told the examples and stories previously, but now we're a little bit of a humor break. I did see a question in the chat. Do they have to take you to court for you to be penalized?
Yeah.
Well, who would pay without a court order? But yes.
Yeah. Small claims court, it's easy to file, easy to do, and easy to judge. It's a black and white law, so judges are very quick to award that. And the penalty is already specified in the Landlord-Tenant Act. So it's very easy for a small claims judge, which, what is the filing fee, $50 or something like that?
38, yeah.
$38. So a tenant's easily going to do that, especially if they're going to get 1, 2, 3 months worth of rent paid
Yes.
to them.
Yeah. Well, I guess I can share the story, finish the story, what happened to that colleague. So basically, the monthly rent was $1,000, in the neighborhood of $1,000, and that realtor left 7 cards, and the tenant said, I never agreed for them to come in, and they never gave me written notice, and it was the homeowner, the landlord, had to pay $7,000 because the caveat is, it is 1 month rent every single time you break this law. So the tenant took him to court and he got awarded $7,000. So nobody was happy.
So it's our job to make sure owners are informed and aware, and we strive all the time to save $50 on this repair, or get it rented for $25 more here, or get it rented in 2 weeks rather than 4 weeks. But then we can see something crazy where it can cost them thousands and thousands of dollars with just one simple mistake. So we get a little concerned when we see potential waste like that.
And one easy way is access. So that was a number 1 point to share with you guys is you get a listing, it's tenant occupied, just be careful when you're accessing the property.
And on that note, it's not so much just, you know, making sure that you have proper notice, or even if you've worked out a showing schedule with the resident, you know, still just be considerate of how frequently that they're showing. This middle one it's an exaggeration. I'm sure that it's probably faked. However, it does drive home the point of they are still living at the property. So just don't over abuse the access. I'm sure that you would feel similar in their situation. All right, next. So this particular slide, I know Dora already touched on some of these. These are penalties that the tenant is able to serve towards the landlord. So things that the landlord would be able to be held liable for. They are outlined by the Landlord-Tenant Act. Later we'll understand a little, Dora will help go into remedies that landlords can have when tenants go out of line. So improper access, again, Dora's already kind of mentioned, the 1 times the monthly rent per occurrence, stress on the per occurrence. Turning off utilities, 2 times the monthly rent. So that's not necessarily just, you know, possibly as, you know, what they can consider as retaliation. Oh, well, you didn't pay your rent, or you're not keeping my property properly. I'm going to turn off your utilities on you. It's not necessarily that mentality, but it could even be as simple mistake as, you know, the tenant forgot to transfer the utilities into their own name, and the landlord, your client, now realizes that, well, I'm not paying that bill anymore. That's up to the resident. Turn them off. You can't do that. You have to serve proper notice so that they have time to transfer the utilities into their own name. Because that's the last thing that you would want to do, is be responsible for forking over 2 times your monthly rent when all it took was a simple notice and some patience for that transfer to happen. Plus, you can then say, okay, well, for the prorated time that you were in the property, here are the bills that you incurred. Reimburse me, please. Things like that. That would be a proper remedy. Missed security deposit due date. Now, A lot of people understand it as 14 days, but it's actually business days. So when you are having an investor client that is purchasing a property, and it was tenant occupied, the tenant is on their way out. Now, the security deposit wasn't necessarily handled in escrow. Now you're faced with, okay, I have to do this security deposit disposition. Let's make sure to advise our client 14 business days, Mr. Owner. Otherwise, you're going to start to face hefty penalties. And what that penalty would be is 2 times the security deposit plus the original security deposit, the full amount. So let's say your investor client was going to say, oh, well, you know, this resident, they messed up the carpets and I got to have them cleaned. $250 of that security deposit. I'm going to keep it for this cleaning. You miss that deadline, you have to give the full sec debt back. You can't keep any of it. So what do you want to do? Security deposit, do it in time, or forfeit 3 times? So failure to maintain. This goes both for utilities, this goes both for maintenance, anything that's, you know, upkeep for the property. Now, this particular topic is not just a right-of-way penalty. So the tenant does have to take action and properly notify the landlord in this case. And they have 2 different courses of action for that, a 10-day or a 5-day. Depending on the necessity of the repair, is it, you know, my toilet's leaking? Or is it, you know, something that would be determined health and safety? Dora, give me an example. I'm losing the tip of my tongue. A health and safety.
So health and safety would be no AC, no fridge.
Got it.
No.
I don't know why I didn't think of that.
You only have 1 toilet in the house and it's not working. Your kitchen sink is not working. So anything that you have one of and now you don't, or more than 50% of your electricity in the house is not working. But definitely the most common ones are no running water, and that could be because they have to turn the water off because their water heater is leaking. So now all of a sudden, hot water is really not a health and safety, but because they have to keep the water turned off, and now they don't have water. So now, you know, all that kind of stuff. So anything that where they don't have, as long as they have a 1 toilet, 1 sink, that's okay. But if all the toilets or all the sinks are out, so but the biggest one is AC and heat.
Yes.
In the summertime.
In the summertime, that's a huge one. So again, minor maintenance versus health and safety maintenance. They have either the 10-day or the 5-day circumstances. If the landlord then does not cure whatever that issue is, then the tenant can have 2 actions after that. They can either self-repair up to half the month's rent, or they can choose to move out. They're free from the lease. It voids the lease and they're due their full security deposit in return.
Regardless of how trashy it is.
I'm sorry?
Regardless of how trashy it is.
Regardless, yeah. So definitely, now it doesn't happen often, the tenants do, but typically, Dor mentioned earlier advocacy groups. There's a lot of savvy residents out there, a lot of groups that are helping helping residents become more savvy in what recourses they have available to them. That's usually where they get the advice as far as serving these notices to landlords. But at the same time, we always want to advise our landlords to, you know, just be responsible. It's part of maintaining your property. You have an investment. All right. Any questions so far on that? I don't think so. Ms. Dora?
Yes. So default in rent, we have a whole other session about late payments and all that. I just want to mention here that when you guys may get involved with rent collection or knowing these timelines, for example, the property owner decides to sell the house and you win the listing and you're ready to list it, and we're giving the tenant notice to move out. And many times tenants, they don't have another security deposit saved up to move because they weren't planning on it. So a lot of tenants nowadays, especially in this hot market to sell, they get surprised. They get a notice, oh, you're going to be out in 30 days. That means that in 2 weeks, now they have to come up with a security deposit on top of the rent that they paid to the old landlord. And many times they don't have that savings. So it often happens that they make a choice of not paying rent the last month of the tenancy, and they're thinking, oh, we're just going to take it out of the security deposit. We don't allow that. We don't recommend it to anybody to do that, because then you don't have any money for repairs if they're using the security deposit for rent. So our rent collection is just as strict. We're sending 2-3 notices before the 5th. We're sending them the 5-day notice, pay or quit notice, and we begin the eviction process because nobody wants to get a judgment. So it is a 5-day notice that we serve. And we talked a lot a couple of months ago when we had another class, we talked a lot about the eviction process. So you guys should already know how long it takes and how involved it is. And then having a holdover tenant just ties right into this topic, because it could be that they already paid us rent, so they paid the rent to us, and now they're having a real difficult time. Either they don't have another security deposit, or it's just like in today's market, a lot of our residents are having a really difficult time finding another property. The sales market is super tight, the rental market is just as tight. So we have been dealing with a lot of holdover tenants, and when a tenant stays even just an extra day, in that case we don't even have a grace period. On day one, we are filing for eviction and a judgment to get them out of the property, and the penalty that the tenant has to pay when they're holding over is 2 months rent. And obviously we communicate to them, we make sure they know this. Very seldom it goes to the full judgment. We usually are able to, but just for you guys to know that if a tenant wants to hold over, there's a hefty penalty for them. And that again is in the Landlord Tenant Act, so it always gets awarded. Failure to maintain, Kayla talked about the 10-day notice and the 5-day notices that the tenant can serve the landlord if something is not repaired, and it goes in the other direction. So when we inspect the properties and we see something that's not right, we can serve the tenant a 10-day notice and a 5-day notice. And just like previously, when it's a health and safety issue, such as the tenant has not picked up dog poop in the backyard for a month, or we go in and it's full of roaches, or or it's very dirty. So it is a health and safety issue. It's a 5-day notice, and they must cure it, and we don't have to serve a second notice. We can just evict on the first one if it's not cured. When it's a minor offense, or it is anything that they're breaking the lease, so they're smoking in the home and they're not supposed to, they have an extra pet that they're not supposed to, that's handled with the 10-day notice. They have 10 days to cure it, and then if they don't cure it in 10 days, or they do it again, even if it's a month from now and it's a repeat of offense for the same offense, we can serve a second 10-day notice. And if that's not cured in 10 days, then it's an eviction. So they need to come into their lease agreement, and that's a pretty good tool. We usually have no problems using that tool to bring tenants back into their lease agreement. And with the access, so the access is not in the Landlord Tenant Act. So so the Landlord Tenant Act says that we have to, the tenant has to give access, but actually there isn't a penalty for it. So we have a workaround way, and if you anytime, let's say that we turn it around, you guys are not selling a property, you just sold a property to your buyer as an investor, and now you are placing a tenant. So now you are creating a lease agreement. And this is one of the most important things, for all the reasons that we talked before, is to put it in the lease agreement that they must accept a 48-hour access notice from you. The reason why you want it to be in the lease agreement is because, like I said, there is no other remedy for them not allowing you to come into the property except breaking the lease. So the workaround is you put the access into the lease, and then when you go to the door, you serve the notice, you go to the door, they don't let you in, then you're serving a 10-day lease violation notice. So your remedy is breaking the lease. Unfortunately, they have to commit the offense twice, right? 10-day notice has to be served for the second time before you can evict it. But in 10 years being in the business, we have never, ever evicted anybody for not allowing us to come into the property. So usually after the first 10-day notice, they get the clue and they work with us. But that is just a workaround way. So just one thing, all the other ones are fine. They're landlord tenant tech, but just this one needs to be in the lease agreement. So, yes.
It's the teeth.
Yeah, the teeth, yeah.
You need the teeth in the lease to enforce it.
Yes. Any questions, anybody?
No?
All right.
See any in the chat so far? So since we're on the God, goodness gracious, since we are already speaking about the lease, this kind of brings us into better understanding of, you know, what to expect at the end of a proper lease. So of course, each lease is different, whether it's AAR, whether it's our lease. And to be completely honest, I'm not very familiar with AAR lease because, like I said, we have our own. So definitely pay attention whether or not your client is, whether you're the selling agent or the buying agent, and the investment properties either has the tenant or soon to get rid of the tenant. Just be aware of, either way, giving proper notice. Again, circling back to proper notice, right? So the tenant is required in our lease, again, pay attention to the terms of your own. But according to the Landlord Tenant Act, the tenant is required to give a minimum of 30 days notice when they're going to vacate. So let's take that, for example, if it's the 20th of April. Goodness, I almost said May. If it's the 20th of April, they're saying, I'm going to be out on the 20th of May. Sorry, it doesn't work that way. It's a full 30-day cycle. So if they give notice today, it would then be, that would be the notice for the end of May. Now, in our lease, and what we would usually advise is for the resident to give us 60 days, because that gives you a little bit of time to get the property back on the market, start looking for your next resident. Now, in this particular market, it's not necessarily that, you know, we all know what the market's like right now. So just be aware. The earlier notice, the better. That way you can already kind of know well in advance what your next plan of action is going to be. Leases don't just terminate. There's always a month-to-month clause where at the end of the term, if no one has given the other party notice, it rolls into a month-to-month basis. So don't just assume that the resident is going to be vacating. And again, in turn, if you're going to be expecting that resident to be out, you need to give them proper notice. In this particular case, 30 days is the minimum. So again, if you give them notice on the 20th, don't say be out May 20th. You have to be out the end of May. And if you miss,
Yeah.
Grace.
I'm sorry.
Yes. All right.
Am I
In
back?
the meantime, while she's unfreezing, we received a question here. Oh, you're unfrozen. Okay. Let me answer this question here quickly.
Yep.
So a property owner wants to go to the backyard to pick some fruit and or to just take care of a tree or some landscaping items. So whatever we said earlier about giving proper notice is absolutely true. You cannot set foot in the yard, front yard or backyard without proper notice. What you are risking is 1 month of rent. If you have what you're if you want to be less formal, we as a property management company, we have to be formal. Every single time we send certified mail. But if you want to be less formal, you can, and you have a good relationship with the tenant, you can text it as long as you have it in writing and they agreed to it. So you just want to kind of show, or for example, you're not that friendly with them. One trick that we do use, because Ashley was telling us about that, you really need to wait 7 days to enter because you have to have a proper 5-day mail time. So there's a little trick to shorten that time frame. For example, we always send the letter certified and regular mail. The reason the certification is for us to have proof that we sent it. The regular mail is because they're going to get that sooner. They're going to open it. They don't have to go down to the post office. And the next day we text them, hey, did you get a notice? Once they text back, yes, you guys can come in, then we have written proof, and all of a sudden it's not 7 days, it's maybe just 2 days or 1 day, or, so as long as the communication is understood and you have some kind of a proof, because, hey, we're property managers, we're jaded, we've heard it all, we're at the door. Oh no, I never told you that you can come in. So, it's like we want everything in writing. But if you're just a landlord, you're working with your own tenant, you have a good relationship, that can go sour anytime. I just recommend that you at least have a text message and a set time frame and their agreement. So if you want to pick fruit in the backyard, just make sure that you tell them 2 days ahead of time out of courtesy. And, the drive-by things usually don't work. So, yeah.
So what was the last thing you heard before I froze?
You were almost done with the whole slide. So, okay. Yeah, we heard almost everything. You were only frozen for like 2-3 seconds.
All right. So I guess my last little point that I didn't quite finish was, if you're giving your tenant notice and you need them out by the end of May, make sure that you don't give them notice past April, because we've had some residents or some landlords and some clients of ours that rushed and they didn't get the notice out until May 2nd. Well, it's still 30 days. No, it's not, because now you're already into May's 30-day cycle. So then technically that notice then becomes the end of June. So just pay attention to your, okay. I'm sorry?
But May 1st is okay.
Yeah.
So just pay attention to your 30-day cycle. All right. A couple extra little funnies. So the security deposits we're about to go over, same thing with fair housing. I don't want to rent to dogs. So I think we've already covered the question section. Moving on. Ms. Ashley.
So we're at the end of the lease, and now I guess we're talking about security deposits. And like we mentioned earlier, it is time sensitive. So you have 14 business days. So if there's a holiday in there, it's not a business day. So there's 14 business days to get that back. And if you don't get that back in time, like Kayla said earlier, it's 2 times the security deposit plus the original security deposit that the tenant would have to get back. Now, the move-in condition and move-out conditions, we take videos. So we, do very detailed videos. So we have never, had to go to court or lost a security deposit dispute because of the videos. So it's very important to document the condition before and after. And we'll talk about the life cycles of, each item too. Another thing that we often have owners ask us about, and you might have your clients ask you, is if they should upgrade the home or update the home. And a lot of times if it's for an investment property and it's a rental, you don't need to spend a lot of money on upgrades and updates. It's not going to get you a whole lot in rent. Just make sure that everything's working, and that should be good. Now, if you're selling the property, it's a little bit different. At the bottom here, you'll see the different life cycles. So we've got carpet that, it's 5 years. Now, normal wear and tear, this is stuff that the landlord or the owner would be responsible in repairing, is gently worn without holes and stains. Now, money that we could take from the security deposit to repair would be from pet stains or holes. So tile, has 25 years. Dirty grout is normal wear and tear. If it has been broken or chipped, we'd be able to take that from the security deposit to make that repair. Windows, 20 years. If it's lightly scratched, that's just normal wear and tear. But if it's broken or any hardware, then that would be considered damage. Countertops have 20 plus years. Scratches and watermarks is normal wear and tear. But if it's chipped or burnt and stains from the tenant, then that would be able to be taken from the security deposit. Paint is 3 years normally. If it's faded or minor scuffing, then that's just normal wear and tear. But if there's markers and paints, if they painted the wall of some weird color, then that would be damage from the tenant. Refrigerator, that normally lasts about 10 years. If there's worn gaskets on the door, that's normal wear and tear. If there's broken shelves or if it was dented, then that would be a charge to the tenant. Air conditioner normally lasts about 10 years. Normal wear and tear would be dirty air filters. Now, if the tenant is neglecting to change those filters, then that would be something that we can take from the security deposit.
We do have one question. It says, do the pictures need to be date stamped? It's definitely, it wouldn't hurt. If they do have them or if they don't have them, you could email them to, if you're, let's say you're the resident, if I were to email, I'm sorry?
So yeah, date stamping is advisable,
Yeah.
especially when you're, whether it's pictures or video, we like to do that within 3 days of moving in. And the reason is many times the judges don't award the security deposit if the pictures were taken too early. So if you take them 2 weeks out, then they say, oh, well, the damage could have happened in those 2 weeks. And when they moved in, indeed, it could have been already in this condition. So that works on smaller items. So the best thing is to do your date stamp. Yes. So the answer is yes. Date stamp pictures within 3 days of moving in. And probably you're going to inspect right after move out. You get keys and you go to the property and you look around. So definitely. A couple of things that I wanted to add to what Ashley was saying is that we always talk about in general terms returning the security deposit within 14 business days. And it's actually not the money that we have to return every time, but an accounting for the money. So the reason why I'm saying it is because if you're keeping the entire security deposit, and you're not returning money or a check, you still have to give an accounting. So actually it is the accounting for the security deposit together with a possible check that is due at 14 business days. Another thing that I wanted to add on all this, you guys see this column of average life. When it comes to paint and carpet, those years actually are years that the judges use to prorate the life of a security deposit. What it means to you is, and actually the other appliances too, but they seldom are prorated because the tenants seldom trash it to the point of total repair. But I don't know if you guys are familiar with prorating it. So we do prorate carpet and paint based on these numbers. So let's say we painted the unit, full paint, tenant moves in, they move out a year later, and we have to do another full paint. So then you got use, 1 year use out of it, 2 years the tenant owes you. So the tenant pays for 2/3 of that full paint job's price, and the landlord pays 1, and the same for the carpet. So those proration years become pretty important. And let's say you did buy a brand new fridge and the fridges are lifetime expectancy is 10 years, they totally trashed it, where you have to replace it, then they owe you 9/10 of a new fridge, basically. So that's how the proration works, and that's why we put those numbers there. And one other thing that I just wanted to mention, where it's gonna affect you guys a lot, and if we managed one of the properties that you referred to us, and now you're getting it back for sale, we can work together on this, because we run into this situation a lot that your owner, the seller, is thinking the tenant moves out and now they can use the tenant security deposit for, okay, let's just do a full paint and let's just do this and let's just do that. So it is really important to educate them to say, no, we still have to follow hot guidelines and we can still only keep so much money. And because you're fixing it up for sale, that doesn't mean that the tenant really owes that money. So that's something where you can work together with your property manager and make sure that the expectations are set right with the property owner.
All right, we have a couple of questions. Is there a way to determine damage from the tenant to the HVAC system, especially if the tenant has only been there for 1 year? Is there a way to tell if it was their fault or the previous tenant?
I have some ideas on that, and a lot of it has to do with general practices. We advocate the fact that we do a quarterly AC filter change, to where we go in quarterly to change the filters. We date and sign our filters so we know that we have done it. So if we come back in 3 months and it hasn't been changed, we know they're not taking care of the air conditioning. In our leases, it may not be in yours, it's not in the AR, that they must change the filters every 30 days. If they're not doing that, they're in breach of their lease. It also states that if they don't change their filters, they could be responsible for AC repairs. So you take that one step further and have a tune-up once a year, just before the season, and have that person document the condition. So document the condition of the filter and the others. And so it's just really policing it and trying to stay on top. And if you can prove that they didn't take care of it, yes, that's one way to be able to prove that it was their fault.
We have never been able to have the tenant be charged for a full AC replacement, but we have several times we went out and it was a inside outside coil clean. You know, those can be expensive, up to $600. So we were able to charge it to the tenant because it is in our lease that they have to change the filter every 30 days, and the filter was filthy. So it was totally, the coils were filthy because the filter was filthy. So we were able to make that connection, and they actually paid for the full coil clean. Yes.
Next up, Jack, I just wanted to mention 2 seconds. We do have a couple more slides we need to get through. At the end, we would be more than happy to stay on just a few more extra minutes with you and answer all your questions, detailing who's responsible for what, or who's ultimately liable for what costs with a security deposit. But fair housing is kind of a larger topic, so we're going to move on and then we'll circle back. Thank you for your patience on that. All right, so fair housing.
Fair housing is huge. You guys take your mandatory fair housing classes. Just a couple of things that we want to mention here that will affect you when you're doing something that you don't normally do. Let's say that you sold the property to investor buyer, and we get this all the time, that you also want to place the tenant to make an extra commission on the leasing side. That's totally good. We're for it, but you're going to run into just these couple of situations on the leasing side. Is that your investor says, yes, Joe, please rent out my property, find me a tenant, but I don't want any pets. So the emotional support animal topic needs to be raised with your owner, because many times, I mean, the support animal topic is out there. Everybody knows they can go online, they can get they can buy a certificate on the internet. There's a whole other topic on that, how to screen for those non-real certificates, but we don't have time to go into it now. But basically, you just need to educate your owners that chances are, if they advertise for no pets, 65% of tenants have pets. Chances are they're just going to have a service animal then. So it's a whole lot better to understand, limit the service animals, understand that they cannot say no to service animals, especially if you're a licensed realtor, you're helping them. If they were doing it on their own, that's one thing, but you're licensed, so you're helping them. They shouldn't be saying no, they need to engage. This is fair housing disability class. It can be a big slap on the hand, on the wrist, if you say no to any person with a disability. So you have to accept service animals. And just a couple of things I want to mention is there is definitely a scrutiny that can go into verifying that the documentation is real. You can never question that disability, but you can verify the documentation to the point where you call the office where this documentation was issued to see if it's real. Couple of other little nuggets to take away. One, they want to put 2 service animals into the property. And I just want you to know that that means they have to have 2 disabilities, because legally, luckily, they can only have 1 support animal per disability. So they have to provide documentations for 2 diseases, 2 illnesses. Thank you, sorry. And then just like with any other fair housing situation, their request has to be reasonable, such as, a blind person is not gonna request an aquarium. So it has to be, the support animal needs to be supporting and helping that person with that disability. So has to be a reasonable and related accommodation that you're making, just like in with any other disability. So that's one thing. And I wanted to mention another thing. I have to peek on my sheet here. So the multiple animals I mentioned, and so let's say that it is an apartment complex, and this is a really vicious dog, for example, that originally you had to accept. You cannot say that they can't have that service animal because they broke the lease. You can say that they can't have that service animal and they can replace it with another service animal. It happened a couple of times to us. They ended up moving because obviously everybody is attached to their pet, but just be careful. And, you can meet the animal in person, you can vet the animal, you can establish if they're friendly or not, and you can request for another support animal if you really want to push the envelope. So the first thing you're going to run into is, I don't want any pets. The second thing is, look, this property doesn't have a pool fence. Okay, but I'm just gonna not advertise for families. I'm just not gonna rent to people with children. So I don't have to really go into details because this is more obvious. You know that we're not supposed to do that for fair housing reasons. Families are a protected class. It is important to have pool safety. So hey, just have your investor put in the pool safety. Another thing that you can tell them why, because they are just as liable for visitors. So if that tenant doesn't have any children, but the neighbor comes over to swim, or somebody, their cousin comes over. So obviously, pool safety, we don't even show a property until, we don't let anybody in a property until the proper pool safety is in place. So you need to be on the lookout for that. The best solution for all the fair housing problems is to have really, really strict systems. We have long processes and detailed, and when it comes to application and maintenance, because a lot of people don't think about maintenance, but actually Caliber Realty got into an audit that they were audited because one tenant complained that they were purple in color, and the other people were green in color, and the green people received service much faster than they did. So there was a whole fair housing audit, And I just wanted to point it out because maintenance can also be a sticky point. So you need to treat everybody equally. The two sticky points are applications, yes, and the leasing process that the previous two images are for, but also maintenance is just as important to have really strict maintenance guidelines, and everybody gets, the AC repaired within 48 hours and not, not all the great differences. So your maintenance systems also have to be pretty structured if you're licensed or if your owner has more than 3 properties. So.
There's a question about the pools as well.
Yes.
So community pools fall into the same guidelines as far as safety. The house itself doesn't have to have the same safety, but the surrounding area around the pool has to be safe. It has to have the self-closing gates and so on and so forth. But in order to protect the owner, the best way to do it is to up their liability insurance. We suggest at least $1 million in liability. We also suggest that the tenant is required to have renter's insurance, and that also needs to have $1 million in liability coverage, listing the landlord as additional insured. So that way they have 2 different policies there to cover not only their own, but also the tenant. If that helps.
And upping the liability is really so much cheaper than you would think, 30, 40, 50 bucks a year, and you get another $500,000 in coverage. So
it's worth it.
Yeah.
Definitely. Any other questions before we do have a couple more slides. A little bit about best practices and some of the experiences that we've seen landlords do.
Now, I can handle some of this. I get lots of feedback from owners and tenants, and I get a lot of, we have one particular tenant who was awoken at 5:30 in the morning. His child was screaming, running into the bedroom, saying there was a monster outside. And it was a post hole digger who was digging for a sign. So someone put their home on the market, put a sign in the front yard, and they had this big post hole digger and woke up the kid and got everybody riled up. So we would think that we would never do something like that. Most respectful realtors would at least have a conversation with the tenant prior to. This one didn't. And when confronted, this tenant called the realtor on the sign at 8 in the morning. The realtor was belligerent. I guess they were upset too, but they were belligerent and said, I don't have to talk to you. I work for the owner. You're just a tenant. So we think back and think, who would say something like that? Unfortunately, it's a whole lot more common than what you think. So we tend to get chasing the sale and chasing the commissions. We forget about other people's, what they're going through at times. So that's one particular story that I have. Just keeping their rights in mind is a big step. It sounds like throughout this whole conversation that we're really, really pro-tenant, and that's we fair to the tenants by all means. But the Landlord-Tenant Act is a fabulous document, and it is loaded with rules and regulations, mostly to the tenant. But there's a few, the important ones, like you got to pay your rent, and if you don't, you get to get out. Those are in favor of the owner. So it's really fair and balanced in that regards, because when they don't do what they need to do, they're out. And when we don't do what we need to do as far as treating their rights, then we're penalized. So the Landlord-Tenant Act is what's guiding our motivation and how we're trying to help you here. But being considerate on their rights is important. If you have a showing, don't miss appointment times. Also, when you're showing a property, look with your eyes, not with your hands. That same particular property that had realtors showing the property, and they called me up and perturbed that the realtors were moving their clothes in their closets so they could see a better view of their closet. This is a reach-in closet, but they just felt like she shouldn't be touching things. So respect.
Respect, and David says that we always work for the property owner, and many of these sides were for us to work together and to help the owners to avoid these pitfalls, because at the end, it is not the property management company, it's not the realtor who pays those penalties. that are pretty steep. So we together need to look out for the homeowner. So all this was not about tenant rights. It was about helping the homeowner not to step into
A fee or
a
penalty.
fee. Yeah.
We are just about out of time, so I just wanted to say thank you guys so much for joining us. I do want to get back to your answer real quick, Jack, but if you guys do have to hop off, please feel free. Thank you so much for joining.
Thank you, everybody.
Please feel
We
free
love your
to reach
visits.
out.
Thanks for stopping into this.
Feel free to reach out, excuse me. Any questions you might have, your client comes into something that's completely unknown to you, we're here, let us know. So Jack, your question was repairs cost $150 for the repair. The landlord charges $250. Is this legal? I guess let me ask you, you can feel free to unmute yourself if you'd like. Now, what is the extra $100 for time, labor? Is it a coordination charge? Just a general upcharge? I guess it depends.
My client, my friend's landlord, there was a problem with one of the sprinkler systems. The vendor came and fixed it, gave my buddy the invoice. He paid it, and then the client, the property manager sent over a bill for another $100 for a processing fee.
It depends on, or specifically, I'm speaking from Service Star's experience. We do have some terms where if there's extra coordination or above and beyond that needs to be happening when it comes to security deposit dispositions, it's outlined to the resident ahead of time. As far as out of the blue charges, Dora, that would best advice come from you.
Well, I have a question, Jack. You said they sent over an additional bill for $100. Was that sent to the tenant or the owner?
No. What happened? The one of the pipes broke on the sprinkler system. Gentleman came over. The landscaper came over and fixed it. Took him a while. He left an invoice with the tenant, my buddy, for $150. But when the property management company billed him, it was for $250 for the repair.
Okay, so I see what you're saying is it depends on what the property management contract is between the owner and the property owner and the property management company. So let's say that a lot of companies, Service Star doesn't have an upcharge, but let's say that this company had an upcharge, so they can bill the owner. The property management agreement says that we can bill you $100 coordination fee, Mr. Property Owner, for sending any vendor. So then the property owner's bill invoice from the property management company is $150 plus $100. So if that is the cost that the homeowner suffers, and it was the tenant's repair, because it is in the lease agreement that the tenant is supposed to be maintaining the sprinkler system. So if it's a tenant cost, then yes, the tenant could be billed for the entire. But we would really need to know if whose responsibility the sprinkler line is per lease agreement. And generally speaking, underground parts are not the tenant's responsibility. And second of all, we need to see the property management agreement between, otherwise the property manager cannot charge extra if it is not written in a contract, right? There is no upcharge with an extra $100.
I just thought it was interesting. I don't deal with property management because I don't like it. I don't want to deal with people that much.
Okay.
Yeah,
It's hard. It's hard enough to sell real estate, man.
Well, we're here to help you
More
out.
power to you. But we would need to look at the agreements basically. So. You know, it's okay.
There was one more question. The fridge goes out. Who's responsible for replacing the items inside the fridge? For example, there was $2,500 worth of insulin.
$2,500 worth of what?
Insulin.
Whoa, okay. Well, the tenant is responsible for taking care of their own goods. The tenant is responsible. The owner is not responsible. The tenant, what we suggest is that they go down to Circle K, get 3 bags of ice, they put their insulin on ice, and they take care of their own property. They can buy a $30 cooler, whatever. They need to resolve the issue because accidents happen.
The other thing to think about there is the renter's insurance.
Mhm.
When things like that happen, make sure their coverage handles things like that.
Good point. Good point.
Renter's insurance, that has those particular clauses, as well as it's their responsibility to get the freezer, and us dictating to them that it happens right. But if they're out of town for the weekend and the fridge goes out on Friday and they see it on Monday and it's toast, that's when their renter's insurance takes over.
Yeah.
Great class, everybody. Enjoyed it.
Yeah, thanks for showing up here. We like it.
Enjoyed having you.
Yeah, I mean,
Question. I have a property coming up in July, my own property that I need to get property management for. Who in your group should I call?
That would be Kayla.
Which agency are you with?
HomeSmart.
Me.
Yeah, okay. Great, thank you. I'll be in touch.
All right. Thank you. Guys, thank you so much for joining.
Yeah, thank you.
Thank you. Bye.
Appreciate it all.